Great. Welcome, everyone, to the September ICODR member meeting. Wonderful to see all of you. We just had a quick debrief of the Future DR conference, that just happened at Stanford. So, Tim, thank you for flying in for that. And today we have a presentation from my friend Brian, who's got an amazing platform he's going to be showing us off called Peacemaker. So, Brian, let me hand it to you.
Thank you very much, Colin. I really appreciate your leadership in this very important dispute resolution industry. And certainly early on, I found you online and saw all the wonderful things that you had created and done to push forward mediators across the globe. And so I appreciate that and you being so open and generous with your time and your expertise with me and inviting me here to be here today with everybody.
Well, Brian, thank you so much for the kind words. In Texas, we say you're as smooth as a pat of butter on a hot griddle. So thank you. Thanks for all the kind statements.
Okay.
But this is all about you, my friend. So
All right.
please.
So I started mediating. I'm 52 years old, and I started mediating cases when I was 40, on the younger side. And pretty early on, I was struck by just how, I would say, antiquated the process is. And I think the pandemic didn't really change that a lot for the types of mediations that I think most mediators are engaged in. That's ones where you have lawyers on both sides, and the primary issue and dispute is money, with perhaps a couple of additional terms to go alongside it. That's primarily my type of mediation. And I think there's a large volume of that out there where money is the primary thing that you're negotiating through the day. And, we all know the antiquities, as I would call them, whether you're on Zoom or in person, when you're out of the room with the person, it's difficult to communicate with them. Oftentimes you find yourself waiting, not knowing when you're going to be needed, without any prompt a lot of times. I think that, we communicate these very important offers, sometimes with complex terms and a lot of money at stake, by playing what I call the game of telephone, where you go in one room and they tell you what their offer is and you write it down, and then you go into the next room and you repeat it, and you hope that you've done right by everybody by remembering, obviously, the dollar amount that has been offered, and then also the other terms, and hope that you haven't forgotten something. And a lot of times I worry that, is my notepad mirroring your notepad? If you have three people in one room and three in another, and they're all taking notes and I'm taking notes too, do they all say the same thing, or have I miscommunicated something, or has someone written down something incorrectly? And as you go through the day, everybody starts writing down the offers and the counter offers and midpoint calculations. Maybe you do those sometimes, maybe you don't. Maybe you mess up the midpoint calculation or just forget about it altogether. At the end, when you're trying to cobble together a settlement and everybody's tired, I think it's a little difficult sometimes to get the term sheet, if you use term sheets, executed. I was very struck very early on with just how many people, practitioners, are unfamiliar with risk analysis. And to me, it is a very important part of the process. And I'm hoping that over time, we're able to educate more lawyers and mediators as to risk analysis, its underpinnings, its importance, and that it become more prevalent. Because I think a lot of people, when you show it to them, their eyes open and they understand why it's so important. But a lot of them either have never heard of it, or they're uncomfortable with the math that goes along with it. So I've tried to, in Peacemaker, incorporate my strong belief in risk analysis and make it easier. And the other thing that prompted me to create Peacemaker was this thought that, even though I'm certainly didn't grow up with technology in my early years, that people in their 50s like me expect technology to be integrated into most things, and the firm belief that certainly if you have a young lawyer in their late 20s, early 30s, and their clients, that they're profoundly disappointed in any process these days that is still legal pad and pen and doesn't incorporate some kind of technology. So I set out about 4 years ago to build Peacemaker, in an attempt to modernize both in-person, online, and hybrid mediations in the simplest way possible. I hope you agree with me as you see Peacemaker operating, that you couldn't make it much simpler. And at the same time, trying to make sure that we keep the mediator at the center, keep the mediator in control of the process, not affect the way that you personally conduct your mediations, your personal style, and to make it more of your silent sidekick that you can use when you want and in the manner that you prefer without interrupting that. I will tell you before we start that it is safe. I used a software developer who has been in the game since the inception of the industry, really 30, 40 years ago. He's a lead software developer for a major corporation. And so this is built in Microsoft Azure with all of the modern securities that you would expect in a software that's going to be used in a legal environment. If you want more information about that, certainly you can find it on our website. It is a web-based application, meaning that the mediator and the lawyers and the clients don't have to download any software. You just go in and create your account. The charge right now is just $20 unlimited use for the mediator, and for your clients is free for the attorneys and their people who use it. They don't have to pay anything. So the price couldn't be better. And the other thing I'll tell you before we start is it's really broken up into 3 stages: preparation, negotiation, and conclusion. And you don't have to use all of it. You can use some of it, the preparation tool, if you don't like the negotiation tool, et cetera. And for that price, even if you don't use all of it, but just pieces of it, I think it's well worth the money. Okay, so with that, I will share my screen and start to show you what we developed. All right, so that's my awful desktop. Apologies for that. First thing I'm going to show you, I'm logged in 3 different browsers. And so you'll see the attorney view and the client view, which is the same. And then you'll see the mediator view. Everybody has this view, which is your inbox of cases. And when you click on your case, the first thing that you'll see is a list of the case participants. And so here you can look from the mediator perspective at who all has signed up to use Peacemaker. So how do I start this? I create a case, and creating a case is very simple. I just type in this information that's at the top. And then I type in the email address for one plaintiff team member, at least one, and one defense member. And Peacemaker sends out an invitation to the people that you include here by email for them to register their account. I call it a cascading registration process because I don't know who all the plaintiff might want to join on their team or the defense. And when the email goes out to them, it says, look, we need you to register your account and any other person who might be a part of your team, not only people who are going to be there for the mediation, but also anyone who cannot attend in person, but would like to receive real-time updates throughout the negotiations of what's going on. I think that's a very important piece because, a lot of times there are people inside of companies in particular that can't be there in person, but it's important enough for them that they want updates throughout the day so that they can make phone calls and be a part of the process at any time if they need to be. So that happens in advance, and the green light means that they've already registered, so they're ready to go. And that happens in advance of the mediation, usually a week or 2. So underneath this, you'll see where the plaintiff's team has already uploaded to me their mediation statement. And they can upload it, but they can also share it with their team members. They cannot share it with the defense. There's no sharing of any information on Peacemaker between the parties. I keep the mediator at the center and in control of that information transfer. The defense has not loaded theirs up yet. The defense hasn't loaded up any risk analysis, but we've gotten a risk analysis from the plaintiff's team. And so I want to show you that risk analysis. I asked the parties when they received the email to register with Peacemaker, it also includes whether or not the mediator has chosen to request a risk analysis from the parties. If the mediator requests it, then the parties hopefully will fill it out. I usually get compliance with that when I request one. And sometimes they don't share it with me. Sometimes they just share it with members of their team and not me, which is totally fine. I think the most important thing is that they conduct a risk analysis in advance. And so I'll start here by showing you the end result, which is not the decision tree that you're used to seeing. I gravitated away from that because I found in a lot of my interactions with lawyers that people understood this form of it a lot more quickly. And so here we just have a table that shows you the chances of it being dismissed by the court in advance of trial, the chance at trial of the defendant prevailing, and then the estimate by the plaintiff's attorney of what the high award, medium award, and low award might be. And then in addition to that high award amount for the anticipated fees and costs through trial, actually, this is from the plaintiff's perspective, I'm sorry. So it takes away the 1.3 and gives you the net recovery amount. And then here you see all these outcome-based values, and then the total case value of $2 million. Of course, that's a suggested case value and really a starting point for the analysis. But nonetheless, I think a very good starting point for the plaintiff's team to start to understand what their case might be worth. And underneath this, you'll see an itemization of damages. So what we do is we say, take this high award amount of $10 million and itemize that so we see where it's coming from. And so it's $3 million in lost wages, $3 million in liquidated damages, $2 million in attorney's fees, and $3 million in punitive damages. And so I get this in advance of mediation from both sides, along with the mediation statement. And like I said, sometimes they don't want to share it with me. Most of the time they do. And this little table here has proven to be extremely valuable to me in preparing for the mediation. Because not only am I getting the mediation statement where they tell me the facts of the case, but I'm getting from the plaintiff's team a concession already that there's a 20% chance of them losing by getting it dismissed before they even get to trial, the entire case. And then at trial, a 32% chance that they're going to lose. So already there's a 52% chance here that the plaintiff team is going to walk away with nothing in the case. And in fact, if they have to go through trial and incur 1.3 million in fees, they're going to be negative 400,000. And so it helps me. Sometimes you'll find that most times it's what you expect because of attorney bias. You'll find that the defense team comes in and their valuation is going to be significantly lower than the plaintiff's valuation. But I've had some really surprising risk analyses as well. I've certainly had the case values cross over where the plaintiff's ultimate case value is lower than the defense. I've also had, not too long ago, a mediation where the defense team told me there was an 80% chance of summary judgment. And normally when you see that, you don't get that kind of percentage chance from the plaintiff's team. They're not going to tell you, there's a 70% chance of losing the case because a lot of times they don't believe it. And if they do, they're hesitant to share it with you. But I had a case not too long ago where the defense said there was a 70% chance of summary judgment, and the plaintiffs in their risk analysis told me there was a 60% chance, I think it was, of them losing at summary judgment. Well, I didn't get that from the mediation statement. I knew there were some concerns there about their case. But seeing that in black and white in the risk analysis, I knew immediately walking into the mediation, I didn't have to spend a lot of time convincing the plaintiffs that the case was risky, right? I mean, I already had the attorney telling me, I know I'm going to probably lose this case before I even get to trial. So the information here can be extremely compelling and important to me as I prepare for the mediation. The other thing that's very helpful to me is this itemization of damage. I used to not ask for this, but then, I started thinking about it, and it really is valuable for me. It's one thing for me to tell you that your best day in court is $10 million verdict. It's another thing for you to break that down so I can see what the components of that are for two reasons. Number one, when I look at this, I see some fluff in here, right? Are they going to get $3 million in liquidated damages and $3 million in punitives? I doubt it. And the punitives number, we all know that's the most difficult thing for you to recover. So, the real meat of this claim is the $3 million they claim in lost wages or profits. And the other reason why I like to get these is because, in so many instances, I find that there's some material disagreement between the parties about that itemization of damages on the special damages side. You might have an employment case where the lost profits estimated by the plaintiff's team in this is $30,000, but then the defense comes up and says their calculation of lost wages is 15 or 20. And so I'll circle that in the risk analysis. So it's one of the things I do in the very opening remarks when we sit down and talk is to say, look, before we break out into caucus sessions, I want to talk to you about this because your special damages calculations are different. And I need to know before we leave this room who's right and who's wrong about their calculation. So I kind of did this backwards. Normally I show you the risk analysis tool. It's available. You'll see, and this is the mediator view. And so the mediator has the risk analysis that it can conduct from the plaintiff's perspective or the defense perspective. The questions are the same. The difference is that if you do it from the plaintiff's perspective, it's going to give you a net recovery after your projected fees and expenses. If you do it from the defense perspective, it's going to add those projected fees and expenses to the valuation. Why is that? Well, because if a plaintiff is going to spend $300,000 to get $1 million verdict, the net recovery is $700,000. But if the defendant is going to spend $300 to defend the case and then have $1 million verdict against them, the total loss is 1.3. And so just by having the parties conduct this risk analysis, you automatically bridge some of the gap because you're taking fees and costs away from the plaintiff's valuation, but you're adding it to the total loss on the defense side. So that's the only difference in the risk analysis on both sides. I designed this to be as simple and quick for the parties as possible. The first question is, what is the chance the case is going to be dismissed prior to trial, either in a motion by granting a motion to dismiss or granting a motion for summary judgment? And then how much money will you spend in fees and costs to get through that stage of the case? The second question is, when you're at trial, what is the chance of a complete defense verdict and the chance of the plaintiff recovering at least $1? And then if the plaintiff recovers at least $1, what's the high award amount that you might expect, the medium award amount, and the low award amount, and the percentage chance of each of those occurring? And then take your high award, as I just mentioned, and itemize that so I know where it's coming from. And then how much are you going to spend in fees and cost to get through trial and final judgment? And so that is done hopefully in advance by the parties. And I'll show you how it generates this report. If I go back, this is the plaintiff's perspective. My internet's a little slow when I'm running so many things at the same time. But this is the plaintiff's. In the same case where I just showed you, they say 20% chance of summary judgment or dismissal, 100,000 in the case by then, 40% chance of the defense winning at trial, 20% chance of them hitting big at 10 million, 50% chance they're going to get 7, and a bad day at trial is 3 million. Here's the breakdown we just talked about of how they itemize it. Here's their projected 1.3 in expenses. So the plaintiff's attorney types all that in and hits view results. And then Peacemaker calculates the risk-weighted value of the case and gives you that itemization. It also gives you the questions that you asked and answered underneath that, so the parties can look back and see, how did we come up with this valuation up here? Well, how did these probabilities, how were they calculated, in case they question that. There's also a sharing option within Peacemaker. So from the plaintiff's perspective, it gives them names. This is their client, the general counsel, so they've decided to share that with their general counsel inside of Peacemaker. And they also have decided to share it with me as the mediator so that they don't have to email it to me. You can also print this to PDF if you want to, save it to your desktop, email it to people, in addition to sharing it within Peacemaker. Okay, so that's the preparation stage, right? First of all, you build your teams in that cascading registration process that I talked about, and then you perform your risk analysis and share documents with the mediator. Now, on the day of the mediation, I don't say anything about Peacemaker during the opening session. I check in advance of the mediation to make sure that I have at least one person registered on the plaintiff's side and one person registered on the defense side, but I don't mention it during the opening session. I don't mention it during the first caucus session with whomever is going to make the first offer until the very end. And it's when I normally say, look, we've talked about a lot. I know that you're going to make the first offer, so I'm going to leave y'all alone to talk about what offer you want to make. And when you're ready to make that offer, I just want you to log into Peacemaker. I don't even tell them how to do it. I'll show you in a minute how to make an offer through Peacemaker. So I'm not going to show you how to do it unless you need help. But just log into Peacemaker and just type in the offer and send it to me, and I walk out of the room. So this allows them time to talk, and you may not do it like that. Maybe you're sitting in the room when they do it. So you just say, look, all right, instead of me writing down your offer, go in Peacemaker and type it and send it to me, in addition to just telling it to me right now. And so I walk out of the room and let them talk for however long they want to, but I don't have to sit right outside of the room if it's in person, and I don't have to worry about looking at my Zoom screen if I'm in Zoom. I go about my business. I make phone calls, talk with my staff, etc. When they're ready to make an offer, they dive into Peacemaker on their phone, their tablet, their laptop, however they want to do it, and type it in. As soon as they send that offer, it is only sent to me. It is not sent to the defense team. And it bumps me on my phone with a text message saying, hey, the plaintiff's team just sent an offer to you. And that's when I, on my phone, typically will hit join session and see the offer that they've made to me. And so when they make that offer to me, I just have two choices: deliver it to the other side or return it to the person who made the offer. And so normally I just look at it, I see what the offer amount they've made, and I go back into the room with them and say, I got your offer. If I have concerns about the offer that they've made, I talk with them about that. And if they agree to rescind that before publication, I just return it to them. But if they want me to send the offer and we're all in agreement, then I have that offer they've made. The only people who know about it is the person who sent me the offer and me as mediator. And that offer is not known to the other side until at whatever point I decide to hit deliver to the other side. And so what I typically do is once I get that offer in hand from the one side, I leave it at the screen on my cell phone. I just leave it there. And I walk into the other room and I orally tell them what the offer is a lot of times, especially if it's early in the day and we're just getting started. And so, you know, if it's first caucus session with the defense team, I'll walk in there and talk with them for as long as I need to, an hour, before I even mention that there's an offer. And then I read it to them from my phone, or if laptop, if it's Zoom. And then I say, look, I'm going to deliver it to you now. And I'm going to leave you all to talk in your caucus session. And when you're ready to make a counter, just send it to me. I'll get it on my phone, and I'll dive back in here and talk about it with you before I send it to the other side. So what we've done is parachuted into a mediation that's in progress. And so you'll see here several things. Number one, the status bar up front, up top. Everybody has this status bar. And right now it lets you know that the defense has made the last offer, and the mediator has that offer, but has not published it to the plaintiff's team yet. And as I said, here are the two buttons. That's all the mediator's asked to do. You run the entire mediation by just choosing one of these two buttons when it's your time to act. And we've got the new offer here. It's a bracket offer for $5 million and 2.5 made by the defense with one term, which is 1 year of indemnity on all warranty claims. And here you can see the prior offers that have been made. The plaintiff started the day by making a $10 million offer. You got a $750,000 offer back from the defense. 3 minutes later, it's a very quick mediation because I'm doing this as a demo for y'all. And it shows you the midpoint starting out at the beginning of the day is 5.375. The plaintiff came back with 8.5 million, which is a decrease of 15% from their opening offer of 10. And it moved the midpoint down from 5.375 to 4.625, which is a 14% decrease. The defendant came back and countered the 8.5 with 1.5, which moved the midpoint to 5 even. And then the plaintiff came back with a bracket offer of 7 million on the top and 3 million on the bottom, with a midpoint of 5. In terms of written terms, the very first offer made, if you click on it, it'll show you what written terms were offered. 3 years of indemnity on all warranty claims and outdoor products, and no price increases for 3 years. So the defense comes back they delete the price increase. They don't want to talk about price increases, but they kept in without any changes the 1 year of indemnity. Actually, they made a change. They made it's 1 year instead of 3 years indemnity on that. And it says here it was altered from the original one that the plaintiff made. The other thing I want to show y'all is while we're at this screen, this is the mediator view, and you see at the bottom there's a chat room for messaging with the plaintiff's team, and on the other side in a different color is a chat room for messaging with the defense team. There are some, the default room is the caucus room, which is everybody who's on the defense team that you would see if you went into the room. And on the plaintiff's side, same thing. The default is caucus. You can call people out if you want to have a one-on-one discussion with them and create your own rooms on the fly. I usually don't use that. I just usually use the caucus room itself to message people. There's also a quick option. If you want to message everybody at the same time, you just hit intercom and you can broadcast to the entire plaintiff and defense teams. If you do that, though, they can't reply to everyone because I don't want the plaintiff's team talking with the defense team without me being involved. If they reply, if the defense replies, their reply is only going to be in their caucus room. If the plaintiff, someone from the plaintiff team replies, their message will only be in that room as well, in their room. So the next thing I'll show you, I'm going to deliver this bracket offer of 5 million and 2.5 to the plaintiffs, and it won't let you do that unless you confirm. Yes, I do want to send this offer to the plaintiffs team. And so when I do that, it's going to update the screens to let everybody know that that offer has been published. So then we're going to go to the plaintiffs team, and I'm going to show you how to enter an offer. You can enter a regular offer, or you can enter a bracket offer. So we're just going to come back with a regular offer. We're just going to say, just to end this mediation, we're going to say, look, we like that the bracket midpoint, the defense offered at 3.75, and we all know that that's probably what they want to settle the case for, and we're just going to be generous and accept that, and we're going to also keep that one indemnity term that we've been negotiating for so long. It's going to make sure, yeah, do you sure you want to do this? I do. And so that gets sent to the mediator, and I'm going to deliver that to the defense. Are you sure you want to? Yes, I do. And then from the defense perspective, find that I'm running all these. I'm running 3 different browsers, so sometimes it takes me a minute to get where I need to be. Let's see. I think I'm looking at this from the wrong screen. So hold on 1 second. Yeah, I'm sorry, y'all. Where did I put that? It's hard to run all these screens at the same time. And sometimes I get lost.
It's complicated, a lot of moving pieces.
Right. Yeah. Well, I mean, I'm trying to negotiate against myself, and we all know that's something you're not supposed to do. All right. So make sure I'm at the right place. Okay. So here's the defense side. And so the defense can make another offer, obviously, but we're just going to accept. And so when you accept it, make sure that that's what you want to do. And then it sends to everybody, gets the same screen. So the mediator gets the same thing as everybody else, offer accepted. And everybody has a choice. You can close out this window or hit view term sheet. If you hit view term sheet, it just gives you a very simple modifiable document like you are in Word, where it brings in the case name, the case number, the amount you settled for, the written terms that you've agreed to appear here. And then it gives you, I worked really hard on this for a long time to try to make a term sheet that encapsulates all the things you would want to button down before you leave the mediation without there being too much in here. So admit liability, of course you're not. Scope of release parties, unilateral release of defendants only by the plaintiffs, global release of all parties by all parties, and then other if you have some other arrangement that you want to have instead. Scope of release claims, is it all claims of any nature, or is it just claims arising out of the subject matter of the case or something else? Confidentiality, a schedule if you want to put that in there of who's going to make the formal agreement, et cetera, or you can take that out by just highlighting and hitting delete. the effective date, this agreement contains all essential terms and is binding immediately, or it's not. And then signature lines for everybody. I don't have a DocuSign capability right now, but you can save this as a PDF and circulate it for execution. Now, when you finish that, if you're the one of the parties and not the mediator, the last thing it asks you is please leave a rating for your mediator. Out of 5 thumbs up, how many will you give this one? How likely are you to use him again? And if you had a good experience with Brian, leave him some feedback so that he can put it on his website and marketing materials, etc. So that is the preparation, the negotiation, and the conclusion as Peacemaker offers. Does anybody have any questions?
Amazing. Wow. There's a lot of comments and questions in the chat.
Oh, good. Okay.
But let me first ask, does anybody have any live comments or questions or reactions, particularly clarification questions about the functionality of the platform?
All right. Well, let's see if.
All right. Well, let's go to the Q&A. So there is a ton of positive feedback about your risk analysis tool, and how cool that is, and how very clear it is the way you've presented it, and how helpful it is for mediators to have that. So Tom, let's start with your question. So you said each side can separately request a risk analysis, but it's not shared, right?
Right. So, but instead of each side separately requesting, when you set up your case, it asks you, do you want to request a mediation, a risk analysis from each side? If you request that they share one with you, the introductory email from Peacemaker to them will say, hey, the mediator is going to use Peacemaker in addition to any online video platform like Zoom. You need to log in and create your account, and the mediators requested that you complete a risk analysis, and if you feel like it, share it with the mediator within Peacemaker.
I actually typed those prematurely because your presentation answered my question.
Oh, good.
Okay.
System actually blends.
How it blends it. Yeah. I think that's really, it's amazing. Please, Tom, did you have something else you wanted to say?
Brian, based on the Silver Tree, it's very similar to, do you know Silver Tree? That
I do.
But your intake form makes it much easier to create the analysis, it looks like. Really excellent tool.
Well, thank you. I'm a big believer in it. And what I wanted to do was because people don't understand it and people are scared of it. And some people have never heard of it. And so I wanted to make it a questionnaire that anybody could complete if you're familiar with your case as a lawyer. And then it just do those calculations and give you a very simple presentation of the output.
Yeah. Tom, please finish your comment.
I'm going to turn it off because you've answered my questions. Thanks, Colin and Brian.
Yeah. No, I mean, Brian, we've talked about this. I'm a big fan of Marjorie Aaron, and she has a lot of trainings that she's done around the use of decision trees and decision science in the mediation room. And then John Landy has written his Lyra book about the same thing, and trying to demystify this for lawyers and mediators to make it clearer. But I love the way that you've done it here, and integrating it into Peacemaker, it makes it feel like it's just part of the process. You don't have to sell it to them separately to say, oh, can we use a decision and science tool? And as you say, when you create the trees and everything, I think some people, they just, their eyes glaze over. They just can't track it. But the way that you ask these questions is so clear, and I think that what's generated is so powerful. And I love the way you narrated through how you use those risk analyses to start the conversation, and you may even get numbers across between the two parties before they even see the other side's analysis. So I think that's really cool and amazingly powerful aspect of Peacemaker.
Thank you. It's been, I did a podcast on the ABA, what's it called? Sessions or something like that.
Yeah.
Resolutions or something like that. I did an entire segment podcast on my experience getting these risk analyses from the parties in advance. The one word of caution I would give is that especially when you're dealing with plaintiffs' lawyers, but also the defense, if they share it with you, they might not have shared it with their client. And so you have to be very careful approaching that with their client if you're not sure. I've had especially on the plaintiff side where a lawyer had a contingency case, we got near the end of the mediation. And so I started talking to the client about the risk analysis. And, number one, I think it's probably a dereliction of duty for a lawyer not to talk about the risk analysis with their client. And if they haven't talked about the risk analysis, at least prepare them for the possibility that the case is a loser and may not do very well in it. I don't think it's enough to just say you have a strong case or I'm worried about your case. I think that using the risk analysis tool communicates risk to the parties in a way that they can understand the strengths and weaknesses of their case much better. And so that was quick, Colin. Golly, he just posted a link to the podcast. But you have to be careful because one way I love to use risk analysis is if you get, let's just say you get an offer for $1 million in a case for a plaintiff to consider. I'll go back and look at that risk analysis, and it might show that their best day at trial is $5 million. And it might show that, most time they're going to get 800,000, and every now and then they're going to really low of like 200,000. And so I'll go and say, look, based on the risk analysis you've given me, there's a 20% chance you don't get anything because you're going to lose in a motion to dismiss or summary judgment. There's a 20% chance you're going to get a very low verdict of 500,000. There's a 20% chance you're going to only get 800,000. And so what does that mean? It means that all told, you only have about a 40% chance of doing better than the current offer they have on the table.
Wow, that's amazing.
And sometimes the number's lower than that. Sometimes it's 12%. And I'm like, look, you don't have to take my word for that. This is your lawyer.
These are your numbers, right?
These are your numbers from your lawyer. And so when it crosses over that 50% threshold, it's very important to note that for the parties. And as you get further along, if it gets much less than that, certainly when that last offer comes across and you feel like there's some hesitation by the plaintiff, I think it gives them a lot of peace in accepting the offer to know that, if they don't, the likelihood is they're not going to do that well. They feel like they've won, right? They feel like they've won if they're walking away from the table with a number that's likely better than what they'd get if they continued.
Well, it's ironic. Your platform is called Peacemaker, and it gives them a lot of peace to know.
Right.
It's funny. I was going to suggest, well, should we use AI to do some of these risk calculations? But I think it's even better that it's from the parties because you can say as the mediator, look, these are your numbers. I'm only just breaking down what you put in. These are your, so it's not like some third party's coming in and doing this risk assessment. These are your numbers. So now let's take a look at the choices that you're confronted with based on the numbers that you shared. Marcy asked a good question. She said, is there a way to incorporate any consideration of time values? A factor that incorporates a sense of urgency for each side, to say, would you rather get $1 million today or $3 million in 5 years? Something like that.
Not presently. And I think that not only that relates to something I've thought about too. Number one, you can go down the rabbit hole of risk analysis. I actually have, and I've shared with Colin, a much more complicated version of risk analysis that takes into account dependent claims versus independent claims, counterclaims, a whole bunch of stuff. I'm afraid though, right now, the world's not ready for that. I think the world needs something as simplistic as what we have, but further along to that issue of making sure they understand the present value of money and the immediacy of getting cash in the next month is this thought I've had of, should the valuation of the case take into account the willingness of the parties to continue litigating it for a year or 3 years or 4 years? Because, if your client says, I must have a settlement today. I cannot go to trial for whatever reason. I had a plaintiff not too long ago who was dying. And so very confidentially, he shared with his lawyer and me that, I cannot walk away from this table without getting a check.
Wow.
And for other people, it could be financial difficulties. There are a number of reasons why people just might want to cut it short and they don't want to do that. But, factoring in personal motivations like that into it is very difficult to do and gets a little further away from, a lawyer's objective analysis of the case.
Yeah, the numbers are very black and white. When you start to put in those other considerations, it start to get fuzzy. Doug asked, is there a way to account for proposals that combine a bracket and an alternative hard number, sort of like a ranged thing, where you could say, I think we have a 30% chance of getting in this range.
Not right now.
There
are a whole bunch of really brilliant ideas I've heard from lawyers about ways we can improve. But anytime you add a really cool thing, it makes the platform slightly more complicated.
No, I agree with that.
I'm trying as much as I can to hit on what I think are the nucleus of what we need. and then hopefully expand, but only in ways that don't make it any more complicated for the mediator to use it.
Yeah, I agree with that, especially in the context of a tool like Peacemaker. If you had a dedicated risk analysis tool, it wasn't going to be shared with the parties, then you can put in lots and lots of other considerations to tweak it. So Tim asked, Brian, very impressive. Thank you. What kind of claims have you used Peacemaker with?
I mediate a bunch of different types. And I think maybe Harold Coleman from AAA said it best. He said, Brian, this tool you've created is applicable in any civil case where it's primarily about money, because the numbers might get busy, but the concepts remain the same.
Absolutely. Tom said, lawyers don't get math. So having this tool educates them and the tool delivers the news, not the mediator. I guess that's not a question so much as I do like seeing it in black and white there. Even what you're doing is you're gathering information from them in one format, you're reformatting it and presenting it in a different, and then you're asking questions as a mediator. It's like, look, these are your numbers. I'm just pushing them around in a different way to think about this. That's very powerful. I like thinking about the psychological ramifications of the representment of their information. We talk about reframing in mediation. That's kind of what this tool does. It's like, let me ask you these questions and let me reframe it. And now let me show it to you in black and white. And let me ask you some questions about your path forward. So I think that's great.
Well, and like a lot of mediators don't want to use the negotiating tool because they say, look, I don't need anything else. When I'm sitting there with the parties, I don't need to have to fool with Peacemaker. In addition, I just want my legal pad and my pen, and that's fine. But if you like risk analysis and you don't want to use it that's fine. Just get them to do the risk analysis in advance, and I think it's worth the $20 a month, for unlimited mediations to do that. There's some other questions in here. Are there conflicts checked? Not right now. Claire, that's an excellent question, but it's something that we could easily add because, the team builder allows the lawyers to build their teams out. And so you end up collecting a fair number of names from both sides, some of which may not have appeared in the prior materials you received. And so I think it's a good way of going back and making sure. But we've got to add a search tool and a little dashboard for that, which we do have planned to do. Someone else asked, who can see the risk analysis once it's generated? Only you, unless you affirmatively share it within Peacemaker with other people by hitting that checkbox. And you can also email it to people outside of Peacemaker if there's someone else you want to see it.
That's great. It is interesting, Brian. I mean, your platform is so cool on the offer exchange side. It's interesting that everybody responded to the risk analysis because that really is innovative in terms of ODR platforms. I don't think anybody has done that. I think if you think about platforms like Smart Settle, they do that kind of facilitated trading, where they get weights. But I think this is the cleanest example I've seen of risk analysis. So it's interesting that so many people have responded to that piece. I mean, you're right. I have to say again, I think that so many ODR platforms are priced absurdly low. And I think your platform is priced absurdly low. So everyone should buy this platform because $20 is like, this is an incredible amount of value for a very small amount of money. So, let's get that price up. But I do think it's interesting that the risk analysis tool is what people have responded to. So you got a lot of mediators on this call. So I'm right after this, I'm going to go click on your podcast and listen to what you said to the ABA about it, because I think that's fascinating.
Well, I went back and listened to it, and I'll tell you my take on it. I am Southern. I have a very distinct drawl, and I'm much more boring to listen to than I thought.
Oh, no. You're selling. No one likes listening to their voices.
Oh, I hate it.
Yeah. It was funny. I was telling Tim when I was in London, on the side of one of the trains, in the tube, in the metro, they had they had a thing from Las Vegas, and it said, go to a place where your accent is an aphrodisiac, which I thought was pretty funny for just some guy who's walking around London. It's like, if I go to Vegas, I'm going to get dates based on this. So there are many places in the world, Brian, where people just want to listen to you talk because they like the music of your voice.
Experience. The first time I ever had a case in New York, I came home and told my wife after a couple of weeks, I said, the ladies in New York like me. They like listening to me talk.
Yeah, exactly. They'll just keep throwing out questions just to listen to the music of your voice. So, but let me ask you just a question about the offer exchange. You said that mediators that have worked in your platform, they're a little bit more reluctant to use that offer exchange, or they just say, well, I'll just do that direct. I don't need to use a tool for that. What have you gotten feedback, both sides? I mean, what are some contexts? I could see in a money-based negotiation that this structured process, would be incredibly helpful, particularly for high dollar value cases, for me to just manage a ton of cases in here. If I'm like an insurance adjuster and I'm trying to work this out, with subrogation with another insurance company, I mean, I could run 30 negotiations at one time. It's really hard to do that over email and the phone. So have you thought about high volume applications for a tool like this?
Well, yeah, you're right. I mean, number one, you can do it asynchronously, right? You don't have to set aside one day to do it. And so there are some applications like that I think that could be very useful. You could use it as like a claims engine. If you've got Morgan suing Walmart 1,000 times a month, you can do an evaluation on both sides and do an asynchronous mediation to see if you can work it out before the complaint is filed.
Totally.
If you've got an arbitration clause that requires mediation in advance of arbitration and you want to get that done on the cheap side, I think the Peacemaker platform, use of it would satisfy that, even if you didn't have a full day or half day mediation. You could get it done a lot faster that way. I do want to talk about one thing, and I'd like maybe some reaction to it if the mediators felt comfortable.
Please.
If you look on our website, you'll see that in the privacy policy, we say very plainly that your mediation session is completely private, and the offers, counter offers, risk analyses, et cetera, made in that session will never be shared with anybody, period. But we do say quite openly and candidly that we reserve the right to anonymize and aggregate statistics that we can pull from all the mediations that occur on the platform. So, and where does that go? I mean, basically, if I stood here today and instead gave just to talk about mediation practice, and I told you on average that my cases settle in the range of $1.2 to $1.5 million, and that 20% of my cases are personal injury cases, and then I found that in Augusta, Georgia, if your medical expenses are $30,000, the cases typically settle for somewhere around $100,000. But if you're in Atlanta, we've seen because of jury verdicts that it's twice that. I don't think there's anything wrong with any of that. It's anonymization and aggregation of the statistics. But I don't know the mood among mediators about that topic. Is that something that causes concern and pause, even to such an extent that people won't use it?
Do people have thoughts about that? How do you feel about that if you use a platform that has that in their privacy policy?
I mean, I think this is one of those gray areas where we all kind of have to weigh in, right? I think we're in the middle of writing those guidelines and what people are comfortable with right now. So I appreciate that you have made it so clear. And yeah, I mean, Colin, we're in the middle of writing the IBA guidelines, the AAA guidelines, UNCITRALs, and this is a really hot topic, right? Privacy policy, especially as we're looking at this blossoming technology, it's a tricky issue. So I think that you've set a really good standard here, and I think we all need to continue.
I didn't do it lightly. I talked to 3 different legal professors who are experts in dispute resolution and mediation before I wrote it. I consulted with the general counsel of one of the best law firms in the world about it, and several other people. And the resounding theme back was anonymization is the first key, right? And aggregation on top of that's even better. But right now, I think that Apple knows my heartbeat, right? Because I've got their watch on. They can't tell you what my heartbeat is, but they can, I think, tell you what the average heartbeat is of the people in my general vicinity, the 10,000 people around here, what the average heartbeat is and how often we exercise.
Tim, did you want to say something?
Yeah, just to say that in England, I deal with insurance, personal injury work, and medical malpractice work, and dealing with volume players on either side, that there may be some concern that how is the data going to be used, and is it going to be used against them? Is it going to be used to game the system? So people get very cagey about it. I think your formula, Brian, is straightforward, and it's aggregated, anonymized, and what's not to like. But in early days, if there was one big player involved, they'll say, well, that's exposing their data. to other people, and there's commercial sensitivity. So those are some of the problems I envisage I might run into if I was to suggest that to volume players. On the other hand, there are many good uses to which the data can be put, and there's a more positive spin. But I find insurance carriers in particular are very cagey about where's their data going, how's it going to be used, can it be used against them.
One thing that I've thought about is including an opt-out, and not only have it in the privacy policy what's going on, but also have an opt-out where a mediator can say, no, I'm opting out all my clients from this. The other thing is that, because the tool involves participation by all the lawyers and parties on both sides, you get everybody to agree to those privacy policy terms. It's just not the mediator taking a risk by saying, I agree to anonymization and aggregation. When the client logs on, or the attorney representative, they have to agree to the same privacy terms. So it does give the mediator a little more cover.
I would say I'm seeing that more and more with web services. When you sign up, they say, hey, we'd like to collect data about what you're doing to improve our services. You want to do that or not do that? And you can say, yeah, that's fine with me, or no. And I always say no. I mean, I do think as a user, I feel like, well, that doesn't benefit me at all. That's only benefiting you.
Right.
And I know you're giving me assurances that this is going to be anonymized and aggregated, but I think a lot of users are very skeptical about that. I mean,
Right.
every day you hear companies say, oh yeah, we're going to protect your information and you can give us all this sensitive information. And then every other day you get a note saying, hey, this is AT&T. We just got hacked. We gave them your social security number and your credit card. And it's like, well, you told me you were going to secure that. So
Right.
I think on the one hand, you're doing the right thing from an ethics perspective to be transparent about it. And an even better thing would be to provide an opt-out. But I think that users have had their trust in those kind of messages undermined by every other interaction that they're having. I think, as you say, I get the sense that everything I do, all that data is being collected and people are training on that data, and it's not going to benefit me. If anything, it may actually work to my detriment.
Right.
Because, they're going to use it to say, well, we've looked, there's 100 other claims like yours and they weren't for real, so we're not going to refund you. It's what I don't have anything to do with those other claims. So this is a key issue. I do feel that AI is going to be everywhere soon.
Right.
So, everybody's going to be gathering data everywhere. Your toaster, your refrigerator, and I think the norms, it's like privacy. At the beginning, people were worried about their privacy violations on Twitter and Facebook and stuff, but eventually, I don't have any privacy. People just kind of gave it up. So I think the culture is going to change and people are just going to presume that data is being collected on everything that they do. But that's not a reason for us in the field to be cavalier about it. So, I think you're in line with best practices, but I think we just have to realize that our users are going to take all of those reassurances with a big, big grain of salt.
So I think the first thing I'm going to do, I appreciate the feedback. I've been toying with this for a while. I think I'm going to update the privacy policy to give an opt-out right there. If you want to opt out, just email me at peacemaker.legal, and we'll opt out all of your mediations. And I've done that on occasion for some mediators who express the concern. And so if anybody here is interested in using the Peacemaker, but they're concerned about anonymization and aggregation, just email me, Brian at peacemaker.legal, and say, I'm going to subscribe to your platform, but I want you to opt out all of my cases from anonymization and aggregation and not use those at all. And I'll reply to you and confirm receipt and obedience with your wishes until then, because I don't want it to be an obstacle to people using it if they see some value in it.
Well, I think that'll work for low volume, but once you start
Right.
to boom, explode the notion that they're going to be emailing you. I mean, let me
Right.
tell you something, Brian, I hate to tell you this, 99% of your users are not reading your privacy policy anyway. So
Right.
it's
Yeah.
good you're thinking about it, but so if you really want to do the opt-out, it's got to be programmatic. It's got to be something in the flow at the beginning when they initiate at the terms and conditions. Are you willing to share your data or not? And then they can click a little slider and that's.
We're going to do that. I'm
Yeah.
going to do that, but that's a little farther down the road for me to accomplish. And so in the meantime, I want to give these people here assurance that if that's
No,
a problem, you just
absolutely.
email me and I'll take care of it.
Well, and I see, people are using Gemini and they're using Claude and they're using ChatGPT and they know all that data is going into their training data set, but they're like, well, the value I get out of it exceeds whatever concerns I have around privacy. So, man, I could continue this conversation. I have so many other questions for you, but we are at the end of our time here. So does anybody have any last comments or questions for Brian? And Brian, do you want to wrap us up?
Sorry.
Oh, please, Claire, go first.
You've mentioned quite a few features that either didn't make sense in this version because you're trying to keep it very streamlined, or that you're thinking about adding down the road. Is there anything that you haven't mentioned yet? Anything that's exciting that you're kind of toying with in the back of your mind?
Yeah. So, I mean, when you start down this rabbit hole, Clara, you and Colin have gone down this rabbit hole many times
Yep.
of founding these companies and then just your dreams about what comes next. And so I've got notebooks full of things that I want to do in the mediation space down the road that I think could be revolutionary. I really do. But things on the immediate horizon, number one, there's not a mediator proposal function in there. You cannot just say, look, I want to settle this case. I think we ought to settle it for $1 million. It'd be great to add because that double blind process is always so uncomfortable when you do it in person, right? So even though this tool is meant to not interrupt your ability to connect with people directly, it's just going to replace your legal pad with your phone to keep up with the offers. Every now and then, it's not a bad thing to be able to distance yourself from the parties. And the double blind process might be the best example of that. You can say, I think it ought to settle for 800,000, and you push that out in Peacemaker, and then they respond yes or no to you directly. And then you don't even have to go in the room and fumble around with what words you're going to use if it didn't work out, right? If one party accepted and the other one doesn't, it doesn't make it uncomfortable. So mediator proposal is certainly the first thing that I've got on the list. A multi-defendant function. Right now, if you have multiple most cases are single defendant, single plaintiff. Some cases are multiple defendant, but most of the time those multiple defendants are going to negotiate as one team and all make offers combined together across. And so Peacemaker allows you to do all that. It doesn't allow you, though, if you have multiple defendants that are negotiating separately from one another, it right now doesn't allow for that. We're working on a multi-defendant capability where you can have up to 50 different defendants negotiating with the same plaintiff's team, and it keeps up with things like, it's got a really cool feature at the top where it says, right now you've got $5 million in offers on the table from the defense plaintiff's team. Right now, you've already settled, and we've parked in the middle $2 million that you have in the bag, in the hand.
Love it.
And now you currently have a total number. You got $10 million that you've put on the table that they're considering. So it's just cool, the kind of things that we can do. Once you start digitizing processes, magic occurs. And I could talk for an hour about the different things we can do down the road.
Well, you're preaching to the choir, Brian. We love that
Right.
too. Starting to think about ideas, that puts a smile on our faces. But I just want to thank you so much for sharing your platform. Thank you for all the hard work you've put in. It's really innovative and very, very cool. And I think you're getting a bunch of us for $20 a month. Come on, I'll go sign up right now and try it out. That's
right,
worth
Colin,
paying just to play for it. So
I've gotten you. Y'all are heard Colin say he's going to sign up. And Claire, you probably
I'm in.
You probably have his credit card number, right? So
Claire's going to be my
I can sign all of
counterpart.
us up, absolutely.
But thank you so much, Brian, and we really appreciate you sharing this, and keep up the good work.
I can't thank you enough for the encouragement and for everybody listening and the wonderful comments that you've made. Founding a company like this is difficult. It's like climbing a mountain.
Yeah.
And you think it's a small mountain, like 2,000 feet, and then you get 2,000 feet up and you see, no, it's Everest. You've got that much more to climb. Right. And so you need a boost of morale every now and then. Connecting with peacemakers like the ones we have here today always energizes me to go out and try more, because it is such a hard job in so many ways. And to get feedback like this from peacemakers, in addition, it warms my soul and makes me want to wake up tomorrow and climb some more.
Sounds good, my friend. Sounds good. We're all climbing the same cliff face. I'll swing over and hand you a power bar on our way up. So, all right. Thanks, everybody. Great to see you. And we'll see you next month. Okay. Take care. Have a good day. Bye-bye.